You have to understand that this is a lifetime decision. So don't take it lightly, because once you do this, there's just no turning back. You can't come back next week and it's like Target where you want to return it. There's no buyer's remorse here. Yeah. Okay.
A judge lays down the law with consequences that last a lifetime. A 17-year-old pulls a gun to save his family, but ends up in handcuffs. Will a surprise legal move set him free? A man battling cancer faces extradition, forcing the court to make an impossible choice between justice and mercy. And a repeat offender pushes a judge to his absolute limit, sparking one of the most intense lectures you'll ever hear. This is courtroom drama at its most raw, and the gavel is about to drop hard. Stick around, because you won't believe how these cases end.
If you were 18, it'd be something else, but you're older than 18, so you understand that actions have consequences, right? All right, you're giving up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers, the right to be arraigned, charged, read in open court. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. So once you accept this agreement, it's done. It's over forever. You can never appeal this. Do you understand? How do you plead to the offense of driving while intoxicated? Guilty. I'm going to find you guilty. I'm going to sentence you to 6 days in jail. I'll give you credit for the 2 days that you've done. You also need to understand one more thing. What we're doing today, from now on, you are facing a minimum of 30 days in jail. The other thing that you need to understand, if you ever get pulled over again, an officer is going to look up your record. If they come to your car and they smell alcohol or dope, they'll see a prior DWI. What do you think is going to happen? Right. So if I were you, even if you have a sip of alcohol, I wouldn't get into a car, because it's huge risk. The other thing is that there's a surcharge of around $3,000 that they put on you. On a second, it's $6,000. Everyone makes mistakes. But if you continue to make mistakes that you endanger other people's lives, I'm really going to stick it to you. And it's going to be monetarily and with custody. You get it? I'm going to waive your fees now, but you come back here with the DWI. Get ready. All right.
Thank you, Judge.
All right, guys. Good luck.
All right.
Mr. Herrera?
Oh, I have to suspend your license. I have to suspend it. I'm going to do it for the minimum, which is 90 days. Don't drive until you get a license. Okay?
Even though it's already been suspended for 90 days?
I have to. Yeah.
On top of that?
Does he have an ALR suspension?
There was an issue with the ALR hearing, and he never had a letter come through. Long story short.
Did it get suspended through the ALR?
Suspended through the ALR.
Okay. I can credit you for that, for the suspension, but you're going to have to get them the dates so that they can, yeah. Okay.
All right, let's break this down. That was a masterclass in judicial warnings. The judge isn't just handing out a sentence. He's painting a very clear picture of the defendant's future if he messes up again. He mentioned a $3,000 surcharge for a first offense and a staggering $6,000 for a second. These are state-mandated fines designed to be a massive deterrent, separate from court costs and legal fees. The judge waived it this time as an act of grace, but he made it crystal clear that the next time, the financial hammer will fall hard, along with a minimum of 30 days in jail. He's essentially saying, I'm giving you a chance, but I'm also setting a trap. Don't step in it.
Good morning, sir. Sir, you're charged with unlawful carrying of a weapon. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. Shh. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On February 5th, 2025, the officer responded to a suspicious person with a weapon on 5900 Gulf Freeway. The officer made contact with the defendant, who was 17 years old. The defendant advised he was inside Jack in a Box while brothers were selling waters outside. The defendant saw a male rushing at his brothers with a knife, pulled out his gun, and pointed it at the male while telling his brothers to run. The officer performed a search on the defendant, locating a 9mm Glock 19, and the defendant advised he bought the gun from a friend for $150.
I mean,
Yes, Judge. In this case, the officer was going off the fact that he performed the search because he indicated there was a firearm. So
he's going to the defense of others.
Yes, Judge.
It's another person.
And it's just the way this is pled is because he's underage. He's below the age of 21. That's the way it's pled, Your Honor.
You hear this?
Hold on, I'm gonna go yell at somebody. Hold on.
Don't know what's going on.
Hi, Judge. Is this young man charged with unlawful carrying of possession for being under 21?
Correct.
Hold on, I've got a kit. Here's the GPS
But I'm
memo.
more concerned about the defense of others. Did you hear it? I mean,
No, hold on.
hold on a second.
Here's
Wait a minute.
GPS.
Let me give you a lawyer, Mr.
Yeah. Oh, I volunteer. I volunteer representation. Yeah,
Give me a record, can you fill that out? please?
I will do that. But here's a GPS memo saying that it's
on a second.
unconstitutional.
You know, representative gentleman?
Oh, hell yes. Here's the Fifth Circuit saying that it's unconstitutional. Here is the United States District Court, Northern District, saying it's unconstitutional. Here's a motion to quash information. I'll just cross out the name.
Great job.
Yeah, I had to get in this fight yesterday and I'm teed up.
Here you go, Mr. Tito.
Thank you.
Judge.
I was
is there
gonna,
PC?
yeah, look, you gotta be very careful. You know, God forbid something happens where you really dig yourself a hole. I'm gonna find no probable cause, but really, you have to be very careful. You know, sometimes you make a decision in life and it can really have consequences, all right? You know what that means, right? Are you in school? It all starts with school, man. You got to get back into school. This is not a good way to go through life. At 17, the more schooling you have, the more money you're going to make. Knowledge is power, my friend. Do it. Make something. Make me proud. Please. You got it. It's going to get dismissed. Be careful, friend.
Yeah. Yeah, literally have all that on because I have a case in another court.
I was going to find no PC anyways. So.
This is exactly why you need a sharp lawyer. Did you see what just happened? The state was charging the 17-year-old for carrying a weapon because he's under 21. But that defense attorney walked in armed with legal precedent from the Fifth Circuit Court, arguing that the very law he was charged under is unconstitutional. He was literally ready for this exact fight. The judge, seeing the writing on the wall and focusing on the fact that the kid was defending his brothers from a man with a knife, a clear case of defense of others, found no probable cause. This kid went from facing a year in jail to walking free in minutes. What do you guys think? Was he a hero or just lucky? Let me know in the comments.
Good morning, Judge. We are here on, over here, Black from yesterday and Hernandez. Hernandez, you had given a bond to him for $25,000. The family has not been able to post it for whatever reasons, but he needs to sign the waiver.
Okay.
And then Mr. Black, you rolled from yesterday to see what he was actually wanted for.
So we're talking about Black now?
Yes, Charles Black. So it was a Kansas failure to appear. It was for driving while suspended and speeding maximum speed. They're not going to do a detainer, but it's Kansas only.
I know that. I mean, I get it. What do you think?
So he has indicated to me that he is in cancer treatments at the not MD Anderson Memorial Hermann, and that he has a family. I asked him because there was an issue about his license, but his mother is willing to drive him back to the state of Georgia to handle these. If you could just admonish him, if the court is inclined to set him a bond, that
I
he
am.
is back
I am.
in 14 days.
I'm okay to send him a bond. I'm not. I mean, it's not egregious and they're theft cases. So
Your Honor, I do want to say Dave is still opposed to a bond, and if you granted
I
a bond,
understand,
anything.
but they're not gonna.
He'd be opposed to anything less than 5 figures. He did want to make a point that he was still charged with intent to deliver twice less than 10 years ago, which was a first degree 5 to life charge, one of which was a deferred that was revoked for a new
That's 10 years ago.
PCS charge. Let me check the date.
Oh, well, it looks like in 21 he had a PCS with intent. Guys, Deputy Miranda, do you mind bringing up Mr. Charles Black, please?
Did they say that in the file that the citizens?
Yeah.
Okay. Good job.
Yeah. I would think the same as what I do. I think the judge wouldn't do.
I think that 5 figures is a little excessive. For sure. Consider that they're theft cases, the other one's a suspended license case, and they're not going to extradite them on the suspended license, right? Because that costs like every time they extradite someone, it's like $3,500 to $5,000.
I didn't know it was that much.
You know that some jurisdictions also make them pay for the extradition cost. Yeah. So,
Dollars they get on
No.
the bus.
no.
And they-
It's thousands of dollars to extradite someone, and they tack them. They make them pay. Good morning, Mr. Black. How's jail? The thing is that this is going to continue to happen until you resolve those cases out of state. You have an open case in Tennessee, right?
Georgia.
I know Georgia, but you also got one in Tennessee, in that
Kansas.
Kansas. Both of those cases will haunt you until the day you die unless you go back and handle those cases. However, it may be all of just hiring a lawyer and reaching out to the courts in Kansas because it's a suspended license case. But it's always going to trail you until you go take care of it. Your lawyer's asking me to set you a bond, and I'm going to, but I have to make it sufficiently high that you realize that we mean business, that you have to go back to Georgia to take care of that case. Do you understand? You also need to understand that I don't play games. If I set you a bond, I'm only going to give you one. I'm not going to do this again. So if you bond out and you fail to go back to Georgia, I will issue a nationwide warrant for your arrest. I'm going to set the bond at 0. And if you don't go back, I set it at 0. I'm going to get you back. And this time I will hold you until Georgia comes and gets you. Do you understand? You have one chance to make this right. So what's the bond amount?
I would ask for $500.
Judge Fletcher, we're asking for a high bond or no bond, 5 figures. That's what Day is requesting.
What kind of bond can you make?
Actually going through cancer treatment right now, so that's the reason I really need to get out so I can do my treatment.
I don't know that. How do I know that? How do I know you're not just saying that? Regardless, you have to go back to Georgia. So
I didn't know I had this over my head, so.
what kind of bond can you make?
I can pay. I'm gonna be able to pay.
I'm good at 1,000. If you want 1,000, I'll give it to you. But I'm not going to play this game, Mr. Black. So this is an extremely low bond. If you don't go back, it's really not going to end up well for you, especially if you're undergoing treatment for cancer. Because understand that if you don't go back and take care of that business and I have to issue a warrant for your arrest and we get you back, you're probably going to be sitting months in there waiting for Georgia to come get you. You understand? Okay. I'm set about $1,000.
Thank you, Judge. And did you tell?
Yeah, you have 2 weeks from the date of your release to go turn yourself into Georgia. Don't go on a plane because they're going to arrest you. You got to find another way to get up to Georgia, and you have to go turn yourself in. Do you understand? If you don't do that within the 2 weeks, I will issue a warrant for your arrest.
Council for reset.
Okay, Mr. Black, good luck.
This is one of the most difficult situations a judge can face. The prosecution wants a 5-figure bond because Mr. Black has a history and is a flight risk with warrants in 2 other states. But the defense brings up a huge mitigating factor. He's actively undergoing cancer treatment. The judge has to weigh public safety against human compassion. He ultimately lands on a $1,000 bond, which is incredibly low, but it comes with a terrifying threat. If you don't show up in Georgia, I'll issue a no-bond, nationwide warrant, and you'll sit in my jail for months waiting for them. He's trusting him, but he's also holding his health and freedom hostage to ensure compliance. It's a calculated risk. Would you have granted him bond at all?
All right, so 1,000. Okay.
Mr. Johnson, you just want him to sign it, Mr. Hernandez? And then that's it for me, Judge.
Thank you, Judge Fletcher.
Good morning, Mr. Eli. How are you? You look great. You know, when you're clean, you know, you look great. You coherent. The unfortunate thing is that we got to keep you here for that to happen. So you said right now in the felony court that there's nothing, right?
No, I mean, I checked last night, they're looking for, rips, meds, warrant, blood.
Looks like they just got a lab report yesterday, so they're still getting evidence as of now.
What was? Let me see.
Yeah. I give it to you.
Yeah, I don't have that. But and I think that it's gonna take a while to play out, Shreya. And I'm willing to hold as well, because I'd like to see what's gonna happen, because I'm not giving up on you. You know, I'm gonna see where this plays out, and I'd like you to go into treatment as well. I think that's the appropriate thing that is needed in us. And I don't know what it's gonna take to get your attention, but hopefully we can somehow before something catastrophic happens, where you end up with a very lengthy prison sentence. So, Shreya, let's just track it. So you're set for the 10th of March. We'll set you for the day after, and we'll see what happens.
Judge, after.
Of course. Absolutely. All right, Ms. Eli, we'll see you soon.
You can hear the exhaustion and the genuine concern in the judge's voice here. Mr. Eli is clearly a familiar face, and the judge acknowledges he looks great when he's clean. But the tragic irony is that it only happens when he's locked up. This is a common struggle in courtrooms across the country. The intersection of crime and addiction. The judge isn't just processing a case. He's trying to save a life. By holding him and tracking the felony case, he's essentially forcing a period of sobriety and hoping it leads to a moment of clarity or an opportunity for treatment. He's refusing to give up on him, even when the system seems to be failing. It's a sad, frustrating cycle, and you have to wonder what it will finally take to break it.
Thanks, Judge.
Thanks, Shreya.
So we just missed each other. He's here.
Do you know what's happening? Oh, you're doing a plea? Oh, okay, great. Got it. Okay. I'm glad that we don't have to. Wonderful. Okay, so just let me know when you're ready. And oh, you ready now? Okay. Marlon King. Good job. I don't know if I like the result, but how old are you? Are you sure you want to do this? Because the problem is that, you know, when you plead guilty, you know, life is hard enough as it is. And when you continue to rack up convictions, all you're doing is you're hosing yourself. It's really hard to get a job. When you start getting all these convictions, you're just making it so much more difficult, man. You know? I don't remember what he had in Louisiana, but I hope that's resolved. Okay. Just straighten up, fly right. If you're hanging out with bad people, don't. Because they're just going to bring you down. What you're doing now is you're pleading guilty to this offense. It's going to go on your record. It'll be there for the rest of your life. This is an enhanceable offense, meaning that if you ever run from the cops again, you will be charged with a felony offense. You're looking at years instead of days. Do you understand? So no deferred, anything like that?
Yes, Judge, the only offer is the jail offer.
Okay, so Mr. King, you're charged with evading arrest or detention. You're facing up to a year in jail and or a $4,000 fine. You guys have worked out an agreement where they're offering you 22 days in jail with credit for the 22 days that you've done. By pleading guilty to this offense, it's going on your record. It'll be there for the rest of your life. You can never take it off. So you give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. So it's final today and forever. You want to do this? How do you plead to the offense, sir? I'm going to find you guilty. I will follow the agreement. I'm going to sentence you to it. Good luck to you, sir. and I'll roll the court costs. Okay. Hi.
Right now.
There's nothing for you out there. Let me express my extreme disappointment that you've now picked up a fourth case. Cannot tell you how disappointed I am. With us in October, terroristic threat. 2 weeks later, another terroristic threat. 2 months later, a reckless driving. And now you've picked up a felony evading in a motor vehicle. Can you tell me what happened in the latest case, please?
In the evading, Your Honor?
Please.
Yes, Judge. So in the evading, it was on February 7th, 2025, and the officers observed a vehicle driving recklessly on Mason Road and initiated a traffic stop. The vehicle proceeded to drive at a faster rate of speed and changed lanes when unsafe through moderate traffic, endangering other drivers. The vehicle evaded for approximately half a mile and ultimately entered a parking lot and parked the vehicle behind the restaurant on Mason Road. And at that point, the black male wearing a bright orange shirt exited the vehicle to the driver's door and ran through a large tree bush and evaded on foot. And it looks like he continued to evade, and he was approached as he ran on foot, moving across all lanes of traffic, ultimately coming to a stop due to him slipping and falling. So after evading for half a mile, he just ran on foot, Your Honor.
Judge, I know that that's not our case down here. My assumption, this is a broad assumption, is that perhaps given Mr. Jenkins's recent run-ins with the law, maybe those cops are familiar with him in that area. I don't know. It didn't articulate how he drove recklessly for the initial stop, but I think Mr. Jenkins maybe has some. I think he expressed to me that he thinks he's being treated unfairly.
Yeah.
So I don't think he was doing this out of his own safety.
You now have a fourth open case. You know, sometimes we have to protect people from themselves because they are their own worst enemy. I think that you're a danger to the public. You refuse to comply with bond conditions. You have a reckless driving with us. You were ordered not to drive recklessly, and now you've picked up an evading in a motor vehicle. I don't know what to tell you, but Mr. Jenkins, I'm now going to revoke the bond on all the cases, and I'm going to set them high because you are a danger to my public. And I've told you over and over and over and over, if you endanger my public, there's only one thing I'm going to do. So now I'm going to set each of your bonds at 10,004. I am now taking away your privilege to drive. You will be signing an affidavit with me today promising me you're not going to drive, Mr. Jenkins. And I'm going to tell you that if I find, because I don't know if you're going to bond out, you know, your now bonds are going to set up at about $40,000. So if you do bond out, you're going to be signing an affidavit with me today promising me you're not going to drive. If I find that you drive, and I'm also going to put a weapon on here, if I find that you're in possession of a weapon, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you drive. Do you understand?
Yes, sir.
I'm also going to order you to have a curfew of 7 p.m. to 7 a.m.
This is the moment every defendant dreads. The judge has lost all patience. Listen to the charges. Terroristic threat, another terroristic threat, reckless driving, and now a felony for evading arrest. He picked up all these while out on bond. The judge revoked his bonds on all cases and set new ones at $10,000 each, totaling a massive $40,000. He explicitly called him a danger to the public. This isn't just a punishment. It's a preventative measure. The judge is using the power of a high bond to take him off the streets because he has proven time and time again that he will not follow the rules. He completely squandered every ounce of trust the court gave him, and now he's facing the consequences.
I'm still living at my home.
We have resources here. We have all kinds of things to give to people: cell phones, tablets, places to live, food to eat. All you have to do is ask, and we can give you things. But now you've repeatedly shown me that you're going to do whatever you want to do. To hell with any conditions that a judge puts on you. That's what you have effectively told me by picking up a fourth case, and a felony case at that. So what you tell me now goes in one ear, goes out the other ear. I just can't.
No, it's on the road for the moment.
The unfortunate part is that these felony cases take a very long time to resolve. And I guess we'll track it. It looks like the felony is set for March 20th. If you want the next day, I'm happy to do it.
Well,
Whatever you would like to do.
See what's the chance of going, I don't want to put them in custody. If there's some resolutions that we can work on. I think on one of them, the Nixon brother, the other one, we're waiting on some surveillance that may have come in already.
Okay, well, take your time, whatever you want. But as it stands now, you're too dangerous for me, Mr. Jenkins. You scare me. So, all right, we'll have you come up short to us, and we'll talk to you soon. Mr. Samuel, you were charged with driving while intoxicated. It's elevated to a Class A misdemeanor because of the high blow. You are facing up to a year in jail and or a $4,000 fine. You have worked out an agreement where they're offering you 3 days in jail with credit for the 1 day that you've done. You need to understand that by doing this today, this charge will go on your record. It will be there for the rest of your life. From now on, if you pick up any more cases, you will be facing a minimum of 90 days in jail. No more slaps, the proverbial slaps on the wrist. It will go on your record. So if you were pulled over in a car and an officer comes up to you, they smell alcohol, and they see that you have a prior DWI, it's probably not going to go well for you. And if you're not in this country with permission and you do any kind of jail time, get ready, because immigration will probably put a detainer on you. Do you understand?
Yes.
What I'm trying to tell you is that even if you have a sip of alcohol, I wouldn't get into a car. You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you plead guilty, it will go on your record. You can never take it off. Is this what you want to do?
Yes.
How do you plead to the offense, guilty or not guilty?
That's
I'm going to find you guilty, sentence you to 3 days in jail, give you credit for the 1 day that you've done. DWI is big business. There is a $3,500 surcharge that normally applies with this type of case that you would be required to pay. We all make mistakes, but the idea is that you don't continue to make decisions that endanger other people. A second DWI is a $6,000 surcharge. If you pick up a second DWI, get ready, because you'll probably get took. Do you understand? I will waive it for you now. But if you don't make any right decisions in the future, get ready. Did you say guilty? I did plead to the offense, guilty or not guilty.
Guilty.
I will send you to the agreement. Good luck to you, sir.
How was the drive through inspection?
90 days.
Sorry, guys, didn't have my coffee this morning.
Me too. I forgot it in the car.
Basically.
What a roller coaster of cases. We saw a young man walk free after defending his family, thanks to a razor-sharp lawyer who knew the law was on his side. We witnessed a judge grapple with the complex ethics of bonding out a man with active cancer treatments and out-of-state warrants, ultimately choosing mercy with a strict warning. And we watched as a defendant with 4 open cases finally exhausted the court's patience, resulting in his bonds being revoked and stacked to $40,000. Each case shows that justice isn't just about guilt or innocence. It's about circumstances, consequences, and immense pressure on judges to protect the public while honoring individual rights. If you found this case as shocking as we did, make sure to hit that like button. Share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.